Today we're going to talk about powers of attorney and give a general overview on what a power of attorney is and can be. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, feel free to like and subscribe to the channel below. It sure helps support the channel. So what I've noticed a lot is that there's quite a bit of confusion about what a power of attorney is and why we need it for estate planning. So to kick this off, I guess we should talk about what a power of attorney is. And it is essentially a document that allows someone to step in your shoes to make financial decisions for you when you become incapacitated. Now, we're talking about a financial power of attorney. There's a couple different types of powers of attorney, but today we're just going to focus on the financial power of attorney. Now, the person who steps in your shoes to make the financial decisions for you is called your attorney in fact, or you can just call them your agent. Their authority lasts from the point that the authority begins until the authority is termed or until you die. It's important to note that a power of attorney cannot have any effect after you die. All the authority goes away. So that's when we have to turn to a will or turn to a trust or some other document to manage your affairs. When we're thinking of a power of attorney, there are 5 different categories in which to break down a power of attorney. There's the purpose, there's durability, there is the scope, trigger, and term. I hope you can read my handwriting. So the purpose of a power of attorney will be, we're talking about here a financial power of attorney, but there's also powers of attorney for medical and there's powers of attorney for guardianship. Today we're talking about financial primarily. Durability basically breaks down into durable and non-durable powers of attorney. A durable power of attorney allows the attorney in fact to have authority while the individual is incapacitated and unable to rescind their power of attorney. If you have a non-durable power of attorney, the second you go into a coma or become incapacitated of some sort, the power of attorney loses its authority. So in estate planning, we're focused more on the durable power of attorney. The third category is the scope. And this, for a financial power of attorney, breaks into 2 categories. There's the limited power of attorney and there's the general power of attorney. The general power of attorney just has broad powers. It can handle any financial transaction that you have. The limited financial power of attorney can be limited as much down to as one transaction, so sale of a property or something. In general, we're going to be, for the estate planning purposes, we'll be talking about a general power of attorney. However, some strategies use multiple limited powers of attorney that covers everything. For instance, you could have a power of attorney that just handles your business affairs and a power of attorney that handles everything else. The 4th category is the trigger, and this is when the authority of a power of attorney begins. There is immediate and there's a springing power of attorney. In an immediate power of attorney, the authority to handle all your financial affairs starts the second the power of attorney is signed. Now that can be a little bit scary. We may not want somebody else to have full authority to go into our bank accounts, our investment accounts, go into our business affairs and change things around. So what we have is called a springing power of attorney. Here, the authority springs when a certain event happens, such as the event that's most common in estate planning is when you become incapacitated. Usually it's by having a couple doctors certify or verify that you've become incapacitated. That way, if it's durable and springing and starting when you're incapacitated, the authority only starts and lasts while you are incapacitated. The 5th category to break down powers of attorney is the term. If you write a term, in Minnesota, you have to write the month, date, and year that the power of attorney authority ends. If you don't have a term, the authority ends when you die. Now, there is a question, and I haven't been able to find the answer to this, is if you can have an event be the point that the power of attorney terms, such as if you become non-incapacitated, become capacitated, I guess, whether you can have that as the point that the authority ends. Realistically, if you come out of a coma, you can immediately just rescind your power of attorney, and that would term the power of attorney as well. In Minnesota, we have what's called a statutory short form power of attorney. Now, the reason this is important is there's a law that says that a financial institution must recognize the authority of a statutory short form power of attorney, which can be important. If you just have your attorney draft a power of attorney, there's a chance that a financial institution will say, I don't respect that power of attorney, I'm not going to respect its authority, and I won't let the attorney in fact make changes to the account. That's a bad situation if you're incapacitated. So the challenge with the statutory short form power of attorney is it's an immediate power of attorney. It is not springing. So as soon as you draft that document, you're giving someone else authority over all of your financial affairs, or a limited number of financial affairs. However, you can be limited or non-limited in the statutory short form power of attorney. So how do we have a springing power of attorney that we make sure that financial institutions will honor? There's 3 strategies you can take. One is you can just sign the statutory short form power of attorney and hope for the best. 2, you can have your attorney draft a power of attorney and, again, hope for the best that your financial institution will honor it. And there's a pretty good chance that they will. The third thing you can do, and this is probably the best idea, is to go to your financial institution, ask them for their form or their language that is required for a power of attorney. Bring that to your attorney and have them draft the power of attorney with the financial institution's language. If you do that, then the financial institution will certainly honor, I would hope, the power of attorney, and you've taken care of the problem. You won't have the protections of the statutory short form power of attorney, but you will have the protections that it is the language from the financial power, from the financial institution. So there you have it. That's an overview of powers of attorney. If you liked today's video, please feel free to like and subscribe below. If you have any questions, ask them in the comments and I'll try to get to them. Otherwise, until next time, this is Gregory Singleton with Signature Law.